Since European settlement began in 1492, Native Americans in the United States have seen their cultures wiped out, their land taken, and even what some have called a genocide of their people. Millions of deaths, alongside a subhuman legal status, crippled the Native American population and contributed to high rates of substance abuse, poverty, and suicide. But in recent years, the United States government has made efforts to grant Native Americans some level of autonomy by classing tribal land as a separate, self-governing government. So just how independent are Native American reservations? Well, throughout the 19th century, Native Americans were rounded up and sent to specific plots of land known as reservations, as per the Indian Removal Act of 1830. As the United States government fine-tuned their relationship with the many tribes, a series of court cases named after Supreme Court Chief Justice John Marshall delegated sovereign authority to these reservations. What this means is that under federal law, each reservation is its own distinct nation with limited dependence on the U.S. government and the state within which they are located. This domestic dependency relationship gives these independent tribes control over their territory. They can levy taxes on tribal members and even hold court cases with legal punishments. They also have to pay U.S. federal income taxes, but not necessarily state sales tax, depending on the reservation. In return, the U.S. government is tasked with protecting and upholding tribal resources and self-governance. This separated but dependent relationship explains how some reservations are federally allowed to build casinos or grow marijuana, as they are considered distinct from their surrounding state. However, out of a total population of about 5 million Native Americans in the United States, only about 22% live on reservations. Still, despite existing as sovereign nations, the land those reservations are on is still technically owned by either the federal or state government. It is held in a trust on behalf of whichever tribe lives on it. Additionally, because these tribes are both subject to federal law and benefit from special concessions within it, it would be hard to say that tribal reservations have unlimited sovereign power. For example, the 1978 American Indian Religious Freedom Act acknowledged that the federal government had long infringed on Native Americans' freedom of religion, as delegated in the First Amendment. In an effort to fix this, special rights were granted, allowing access to historical religious sites and the use of sacred objects which may be legally prohibited or regulated otherwise. In fact, a 1994 addendum to the act specifically approved the use of peyote, an illegal hallucinogenic drug, in spiritual ceremonies. In the end, it's difficult to say how independent Native American reservations are from the United States. The process by which tribes first received any form of rights, continuing on to special concessions and eventually quasi-sovereignty, is narrow and complicated. By some measures, tribal reservations are not only subject to the United States, but federally owned by them. In other ways, they are intentionally and distinctly treated as foreign autonomous territories. So which is it? Realistically, both.